July 2025, the world's highest court ruled that countries can be sued for the greenhouse gases their predecessors emitted decades ago, a decision that rewrote the legal architecture of climate accountability. A 89-year-old Tibetan spiritual leader announced he would reincarnate, setting off a succession contest between the world's oldest democracy and the world's most powerful authoritarian state. And in Southeast Asia, a border dispute between two ASEAN neighbors turned into a shooting war. 3 stories about what happens when old frameworks meet problems they were not designed to solve. On July 23, the International Court of Justice issued an advisory opinion that fundamentally altered the legal landscape of climate change. The court ruled that states have an obligation under international law to protect the climate system and, critically, that states can be held legally responsible for breaching that obligation. Countries could now, in principle, sue each other for the harm caused by historical emissions. The ruling had been requested by Vanuatu, the Pacific island nation that had led a coalition of climate-vulnerable states through years of diplomatic work to get the question before the court. The states most exposed to rising seas, intensifying storms, and saltwater intrusion into freshwater supplies, the countries least responsible for cumulative global emissions, had asked the court to tell them whether the countries most responsible had a legal obligation to them. The court said yes. The practical implications were immediate and complicated. The IJGI opinion was advisory, not binding. It did not automatically create liability or trigger compensation, but advisory opinions carry significant legal weight in the international system. They inform the decisions of other courts, shape treaty negotiations, and alter the terms of diplomatic conversations. What the court said in July would reverberate through climate finance talks, loss and damage negotiations, and sovereign litigation for years. The ruling targeted the gap between what climate science has established and what the international legal order had previously recognized. Science had long been able to attribute specific emissions to specific countries and link those emissions to specific harms. The question of whether that attribution translated into legal liability had been unanswered. The IJGI answered it. The gap between scientific responsibility and legal responsibility had just narrowed. For the major historical emitters, the United States, the European Union, the United Kingdom, China, Russia, the ruling created a new kind of exposure, not immediate, not simple, but real. Climate litigation had been growing in domestic courts for years. The IJGI opinion gave those cases international legal grounding they had previously lacked. The era of burning fossil fuels without legal consequence was beginning to close, one court ruling at a time. The deeper question the ruling raised was one that no court could answer. What does accountability look like for diffuse multi-generational harm caused by the accumulated decisions of billions of people across 200 years of industrialization? The IJGI established the principle. The mechanism for translating that principle into actual justice for Vanuatu, for Bangladesh, for the Maldives, for every nation watching sea levels rise remained to be built. 3 weeks earlier, on July 2, a different kind of succession question had been placed before the world, not by a court, but by the Dalai Lama himself, in an announcement that set Beijing and Dharamsala on a collision course that had been building for decades. The 14th Dalai Lama, Tenzin Gyatso, turned 90 in July 2025. He had led the Tibetan government in exile from Dharamsala, India since 1959, following China's annexation of Tibet. For decades, the question of his succession had loomed over Tibetan Buddhism, not because of age alone, but because of a specific political threat. China had declared its legal right to approve the reincarnation of all high Tibetan lamas, including the next Dalai Lama. On July 2, the Dalai Lama confirmed he would reincarnate and that the process of identifying his successor would be conducted according to traditional Tibetan Buddhist methods, not Chinese state procedures. The announcement was a direct challenge to Beijing's claimed authority over one of the most significant religious succession processes in the world. The 15th Dalai Lama, whoever he turns out to be, would be identified by a tradition, not by a government. China's position was legally codified and politically non-negotiable. Beijing's 2007 law on the management of Tibetan Buddhism explicitly required government approval for all reincarnation recognitions. China had already appointed its own Panchen Lama in 1995. After the Dalai Lama recognized a different 6-year-old boy who subsequently disappeared, the pattern was clear. China intended to control the next Dalai Lama, and it had both the legal framework and the political will to try. The significance of the announcement was not just religious. The Dalai Lama is not only the spiritual leader of Tibetan Buddhism, he is the most visible symbol of Tibetan national identity and the primary vehicle through which Tibet's cause maintains international attention. A Chinese-approved 15th Dalai Lama would be a tool for legitimizing Beijing's claim that Tibet is content under Chinese rule. A traditionally recognized 15th Dalai Lama living in exile would continue the argument that it is not. The United States and multiple Western governments had passed legislation recognizing the Dalai Lama's authority over the succession process. India, which hosts the Tibetan government in exile, had complicated strategic interests in both the religious question and its relationship with China. The international community's recognition of whichever candidate emerged would determine which Dalai Lama the world's approximately 6 million Tibetan Buddhists would follow. The Dalai Lama's July announcement did not resolve the succession question, it sharpened it. The 14th Dalai Lama is still alive and still leading, but he has named the terms of the contest. When he dies, there will be 2 candidates for the 15th, one recognized by Tibetan tradition and the international community. One approved by Beijing, which one the world accepts will say something important about who has sovereignty over religion and identity in the 21st century. As the Ichki and the Dalai Lama raised questions that would take years or decades to resolve, in Southeast Asia an older kind of dispute was producing immediate consequences: a land border conflict between two ASEAN member states that turned deadly in July. The border between Cambodia and Thailand had been disputed in sections for decades, a colonial-era legacy of imprecise mapping that successive governments had managed but never fully resolved. In July 2025, the management failed, armed clashes broke out along the contested frontier, killing at least 39 people and displacing more than 100,000 civilians from villages on both sides of the border. The immediate trigger was an incident at a contested temple complex in the Preah Vihear region territory that the International Court of Justice had ruled in Cambodia's favor in 1962, but which Thailand had never fully accepted. Competing troop movements and a disputed flag raising escalated into exchanges of fire. Within days, what had been a chronic territorial grievance had become an active military conflict between two countries that were supposed to be partners inside the same regional organization. ASEAN's response was measured and deliberate, which is to say, slow. The organization operates by consensus and non-interference in member states' internal affairs, a principle that extends by practice to disputes between members as well. Emergency consultations were called. Statements were issued, but ASEAN's institutional design was not built for rapid intervention, and both Cambodia and Thailand had domestic political pressures that made immediate de-escalation difficult. The conflict exposed a structural tension inside ASEAN between the organization's stated goal of maintaining regional peace and its foundational principle of sovereignty, which limits its ability to act when peace is broken by its own members. ASEAN had been more effective at preventing external interference in Southeast Asia than at managing internal conflicts. Cambodia-Thailand revealed the limits of that model. A formal ceasefire was signed in Kuala Lumpur in late October, on the margins of the annual ASEAN summit. The 3 months between July's outbreak and October's settlement left communities on both sides displaced, cross-border trade disrupted, and a relationship between two neighboring governments more damaged than it had been in a generation. The ceasefire was signed, the underlying territorial dispute was not resolved. The Cambodia-Thailand conflict was a reminder that in Southeast Asia, as everywhere else, the map from the colonial period and the facts on the ground rarely match, and that when they diverge, in the wrong moment, with the wrong leaders, the result is people dying in border villages over lines that were drawn by empires that no longer exist. The history does not expire, it waits. Free events 1 month, a court ruling that told the world who is legally responsible for the atmosphere, a spiritual leader who told his government that it does not get to choose his successor, and two neighbors who reminded Southeast Asia that old maps create new casualties. July 2025 was a month about the persistence of unresolved things: the emissions from a century ago, the colonial borders, the disputed successions, and the moment when persistence becomes a crisis.